established this mandate in 1994, mandate of the Special Rapporteur on Violence Against Women. I'm very honored to be the first mandate holder to conduct official visits to Canada as a country with feminist government, feminist foreign policy, and feminist international assistance policy. My focus is on national framework and challenges with respect to protection of violence against women in Canada. I have had opportunity to spend my 13 days within a country to visit different provinces, to have meetings with different state officials at the federal level, at provincial and territorial level, also with independent human rights institutions like commissions on human rights, with parliamentarians, with non-governmental organizations, and other representatives from different fields working in area of violence against women. I have visited also 2 correctional services for women in Iqaluit and in Winnipeg, and I have also had video conference with a number of those that were not able to be present in person, like with the Chief Commissioner on the National Inquiry into Missing and Murdered Aboriginal Women and Girls, and Minister on the Status of Women. I have already mentioned that I have visited correctional facilities, but in addition to that, I have visited a number of shelters, number of places in which women victims of violence are seeking safe place and refuge, and I had opportunity to listen their voices, to listen to their stories. I also had opportunity to meet with indigenous communities to listen their stories and their concerns, and based on all those inputs and documents that I have received previously, I have provided my preliminary findings to the government. I already had a meeting with the government, and I already presented my preliminary findings that are focusing on some key areas, and later on I will be in position to present full report with a full set of recommendations to the Human Rights Council next year. At this stage, I would also like to mention that visiting provinces was very important, and I have seen many good practices related to different services available to victims of violence, clinics for victims of violence, but I have also seen shortcomings that should be urgently addressed. In my recommendations, I am focusing on legislation and policies, and I have, after this examination of the situation in the country, come to present recommendations that are related to legislative framework in the country on violence against women. I would like to propose to Canada to consider adoption of federal law on violence against women and domestic violence, and also to consider adoption of a national action plan on violence against women and domestic violence, with a separate action plan on violence against women on Indigenous women and girls. And reason for this proposal is that if we look at different provinces, and if we look at current state of art with respect to services available, we are seeing many differences and different implementation and incorporation of international norms contained in a CEDAW Convention on discrimination against women and violence against women. So each province should be somehow looked with respect to implementation of human rights standards here, and in order to have consistent policy, the best would be for the whole Canada to look into possibility to elaborate with participation of all provinces and territories and all groups, including Indigenous women, national policy on violence against women that would be based on human rights standards already accepted at the international level. So those standards are showing in direction which services are needed, what are standards, and what should be available to all victims in all parts of the Canada in terms of protection orders, in terms of shelter places, in terms of helplines, crisis centers, and also criminal justice system should also address its part with respect to prosecution of perpetrators and application of this set of norms. At the global level, Canada has accepted CEDAW Convention and optional protocol to CEDAW, but has not yet accepted regional instrument that is very important in this area. It is Belém-do Pará Convention, or Inter-American Convention on Protection of Violence Against Women, and also has not accepted UN Optional Protocol to Convention Against Torture. Since both instruments are extremely important for legal framework of Canada in this area, I would like to urge Canada to consider urgently ratification of Belém-do Pará and optional protocol to Convention Against Torture. With respect to international treaties, it is also important to mention that they are not directly applicable, so it is not possible to directly apply accepted UN and regional treaties. So it is a process of incorporation, and for that reason, legislative measures are needed and implementations measures are needed. I have mentioned law on violence against women and domestic violence and national action plan. I would also like to mention that with respect to criminal justice system, there is a federal law that is dealing with assault and different forms of violence against women, but it is important to focus on its implementation and how to improve implementation at the level of provinces and territories. And here there are suggestions for additional education of police officers, prosecutors, availability of legal aid for victims of violence, and so on. With respect to mechanisms for implementation, I have seen that there are possibilities already established for meeting of ministers at federal, provincial, and territorial level that are dealing with human rights, and maybe that platform could be used for implementation of international treaties in area of human rights, including women's rights, and recommendations that are coming out from different treaty bodies and special procedures like my mandate. With respect to national action plan on indigenous women, here I would like to come to national inquiry that is ongoing on murders of Aboriginal women and girls, and here I would like to mention that I have seen process when it started with adoption of CEDAW Committee's inquiry and recommendations for Canada to urgently address issue of missing and murdered Aboriginal women and girls as a grave violation of the CEDAW Convention. And CEDAW Committee recommended different measures. One of those measures was establishment of national inquiry. But in the same time, CEDAW Committee recommended other measures. CEDAW Committee recommended focus on social and economic conditions as the root causes of this type of violence, and also focus on elaboration of national action plan with monitoring mechanism that would be available to monitor implementation of different recommendations. And CEDAW also at that time pointed out to different measures that are needed, so already elaborated what should be in that plan. So now I am thinking that what is coming out from my visit is confirming that those measures are not yet there, and that, for example, this overrepresentation of Aboriginal women and girls in a correction system was at that time already addressed, but situation is similar or even worse today, because if we look at data that are now available also from official bodies here in Canada, it is clear that numbers of Indigenous women in prison system are on increase. They are increasing, they are not decreasing. And if we look that if you see that this is a trend, it is really a very urgent thing that should be addressed. Also, with respect to colonial past and issues related to residential school system, and also problems of taking over children from Aboriginal communities and placing them in state system. We are seeing that this is a huge problem that was not properly addressed, and I have heard concerns of many Indigenous communities and persons that are having personal experiences with the system that is really not supporting mothers to stay with their children and to receive additional support and help that is needed. So basically on this inquiry, I think that is ongoing. I would like to say that I have seen this as a positive process that is going throughout the country at level of different provinces. But however, I would like to say that I have heard different voices with respect to this inquiry. There are many voices that are praising inquiry as a process that has opened the healing process, and I support that view, that opened dialogue between each Indigenous and non-Indigenous community, and that is really addressing past colonial policies and racist policies, discriminatory pieces of laws that should be changed. And here Indian Act is really a piece of legislation that should be changed immediately. That was already pointed out many years ago by different international bodies, but now I see that this act was not yet fully in line with international standards. I have also heard some voices that are expressing their concerns that this inquiry is going for 2 years, that it is not clear what are going to be results, that there is no sufficient human rights focus, and they would like to see actions now. And I think that it is really on government and Indigenous community to decide how to proceed. But from my side, I would like to state that I have seen this process in a framework of laws and policies that are showing specific gaps. And I have also seen that the same question is addressed also by additional inquiries. For example, there is ongoing inquiry at provincial level in Quebec that is dealing with violence against Aboriginal women and girls and misconduct of police force in specific case that happened there. There is also inquiry request with respect to Tina Fontaine in Winnipeg after her killing, because it was showing that system was again failing Indigenous girls like Tina, and when she was placed in these hotel facilities without supervision, it was clear that something is wrong with the system, that there is a systemic problem, and I hope that this is going to be addressed at the systemic level. But basically, it is important to see that in addition to this national inquiry, urgent actions are needed now. They are needed. They could be done now, irrespective of decision if this inquiry is going to be concluded soon or prolonged in order to complete process of testimonies or what is in the mandate of this inquiry. Because this inquiry is not having mandate with respect to all those issues that should be addressed. Related to criminal justice system, related to high number of Aboriginal children in welfare system, high number and overrepresentation of Aboriginal women in prison system, so economic and social issues. So all those issues should be addressed now by this action plan that would be specific, that would be at the level of action plan for non-Aboriginal women, but with specificities that that are addressing standards already elaborated in UN Declaration on Indigenous Population that should be indigenous-led with full participation and all requirements that are there. Let me briefly mention that over-incarceration of indigenous women in prison is something of a grave concern, something that should be urgently addressed, and something that is clear governmental responsibility, because governments are behind those policies. And I would like to say that I have seen audit report on correction service report from ombudsperson that is dealing with correction authorities, and they are all acknowledging the problem. They're all saying that system should be changed, that there is overrepresentation in high-level security correctional facilities of Aboriginal women. I have personally seen them, many young women with many children that are in a small cells, 4 of them, 2 sleeping on the bed. And there are policies that should be changed with respect to their security, with respect to solitary confinement, strip search, lack of educational possibilities while they are there. So I think that everything is already acknowledged by the government, but there are no actions. So actions are really needed, and they should be done in line with Mandela and Bangkok rules and other norms that we have at international level. There are also some other concerns with respect to girls with disabilities and women asylum seekers and refugee and immigrant women. And here it is important to acknowledge Canada's long-standing policy in welcoming immigrants in the country. I have seen many non-governmental organizations that are now providing significant help to women that are seeking asylum, that are in detention centers, but there are also problems related to their permits that should be resolved, that should be granted on humanitarian ground and ground related to violence against women. Also persons in detention that are staying there without time frame, how long they are detained with their children. So all those things should be urgently addressed. I would like to mention that there are also positive developments related to, let's say, criminalization of new technology facilitated violence against women, like non-consensual distribution of intimate images. And here, at this level, Canada is showing to others that form of gender-based violence could be addressed at the federal level. So that could be important, good practice for other countries. On other issues, I will put forward recommendations in a report that is going to be presented to Human Rights Council next year.
Joanna, do you have a question?
I do, yeah. Joanna Smith, Canadian Press. Hi. Just first of all, on the inquiry, you mentioned that, okay, so having the inquiry in and of itself is a CEDAW recommendation, but that the mandate didn't really take into account economic and social issues. But when the mandate of the inquiry came out, there was actually criticism that it focused too much on that and less on actual individual cases. There had been calls for looking more at individual cases. So I'm just wondering if you could explain a little bit more what you mean about things like child welfare not being looked at, things like systemic discrimination not being looked at, when that seems to be the goal of the inquiry.
Thank you for this question. It is my understanding that this inquiry has specific terms of references. So this inquiry is going to address what is in its terms of references. And process up to now was established around testimonies provided by families that are having possibility to engage and to have this focus on past. But it is also my understanding that this inquiry is not addressing all relevant issues for indigenous women and girls and violence against women. And all other things should be addressed urgently and should not wait until completion of this inquiry that are not going in that direction. So it is important to assess what is scope of that inquiry and what other things could be done immediately with other tools that are available for the government. I'm suggesting that those specific issues like like overrepresentation and incarceration of indigenous women should be addressed immediately. There are clear data, clear norms. Process should start with respect to Aboriginal children in institutional care. This should also be revisited. And basically, I'm saying that this could be done through national action plan that will be integrated policy that will look into different parts of the system, because it is not sufficient to look only on one issue without connecting this with all other issues. And also collection of data is very important, because I have not mentioned data. I am advocating collection of data on gender-related killings of women in general. And in Canada, it would be important to have collection of data for Aboriginal and non-Aboriginal women with respect to gender-related killings, and then to have analysis of cases in order to see systemic problems and how to prevent in the future such horrible form of violence against women. I have seen some practices with that respect. There are now some already established femicide observatories that are collecting data. The government is also partially collecting data on femicides, but it would be important to have a clear understanding what are family and intimate partner-related femicides for Aboriginal and for not Aboriginal women and girls, and then what is under the rest, and then to have understanding how to prevent such cases.
You said many times CEDAW.
CEDAW. CEDAW is a committee and convention. Convention is Convention on the Elimination of All Forms of Discrimination Against Women. CEDAW is Committee on the Elimination of Discrimination Against Women. Okay. It is international body of 23 experts that is monitoring implementation of convention and issuing recommendations to Canada and all other state parties, 189.
I find interesting you're concentrating on a lot on the Aboriginal woman. When the inquiry was put together, a number of people said we don't need that. We have to act right now. Do you consider that the inquiry is really necessary, or it's a diversion right now when you look at it?
I think that the inquiry was a good process and is a good process. And it was also suggested by Committee on the Elimination of Discrimination Against Women. But what I'm saying is that this is not the only recommendation. It was done together with, let's say, 20 other recommendations that are addressing situation of violence against indigenous women and girls. And now what I'm seeing is only inquiry process ongoing, but other processes are not implemented and ongoing. So I'm trying to say that inquiry is a good process, but in addition to this, others should be urgently addressed.
I would go on the line. Is there is there anybody on the line that want to ask question?
No, there are no questions registered on the telephone lines.
You have an exhaustive presentation,
Thank
I have
you.
to admit. Huh? Yeah, go ahead.
Yeah. First of all, I have a couple of questions, if I may.
Yes.
Thank you. So you called for a federal law on violence against women, and I'm wondering what you mean separately from the criminal code. Like, what are you calling for in terms of federal law?
Yeah. Criminal code we have in all countries all over the world, and criminal code is gender-neutral piece of provisions that are dealing with sexual assault and cases assault that is dealing with different forms of violence with respect to women and men equally. But when we are looking at other countries, majority of countries do have a specific law, first law on gender equality, or the law that is dealing with equal rights of women and men, and then law that is dealing with violence against women and domestic violence. There are different models in different countries. Some countries are looking, in Latin American context, they have laws on violence against women. European countries have laws on domestic violence, but majority of countries are trying to cover violence against women and domestic violence. And in that framework, it is important to see that CEDAW Convention recently adopted the new General Recommendation number 35 on violence against women, and basically explained what should be in that national framework on violence against women and domestic violence in order to have good prevention of violence, to have a comprehensive set of services for victims of violence, to have prosecution of perpetrators within criminal justice system, also crimes that should be addressed by criminal justice system, including psychological violence, emotional violence, physical violence, and sexual violence, and also to look into comprehensive set of policies that is putting all this together in an integrated system with a mechanism that is observing implementation of those policies through collection of data. So now it is clear that it is not sufficient to have only criminal law, because only criminal law is not giving all those results. And I think that this is partially addressed at the provincial level because they have adopted their provincial national policies on domestic violence and violence, but they differ, they are different, so they are not really comparable. Some have higher level standards, others are not having such standards and so on, and harmonization is needed in order to have this human rights protection at the level that is needed in all provinces and territories.
I'm curious also, when you met with the federal government and they were talking about their gender-based violence strategy, did they call it a federal one or a national one? Because they initially said they'd be bringing in a federal one, and then they kind of started calling a national one. So what did they call it?
They have adopted already federal strategy on gender-based violence, and that one is positive, but this is not the same one that I'm now recommending, because that one is at the level of strategy that is focusing on specific areas like prevention and collection of data and allocation of funds in that respect. So that one is a good step. It's really commendable, but it's not showing what are those standards that are needed for protection of human rights in level with international standards. So I think that now this framework is something else that we are now trying to see through that national action plan on violence against women and domestic violence.
And then, given everything you've learned over the past couple of weeks, do you think the federal government should be calling itself a feminist government?
This is a good question. I applaud the government for calling itself a feminist government, and I think that it is important recognition of political will to advance women's rights at international level. The same policy and political will is needed to address violence against women and domestic violence at domestic or national level.
So I guess what I mean is, though, do they have a... I see what you're saying about, it's good them calling themselves that as to show a political will, but do you think they're really serious about it?
It will depend on response to those recommendations. If recommendations are going to be accepted, implemented, and so on, I think that it is going to be sign of the same level of commitment that we are seeing at foreign level with respect to domestic level.
Did you look at the question of the sex workers and the prostitution? Because the different debate in Canada, so it was a subject in the past. Is it still a concern right now?
I have heard and I have received some inputs, different type of inputs from different sources. Now I'm collecting more data on this, but it is certain that on this issue there are already standards that could be put forward with respect to focus on demand side, because demand should be addressed properly by the government. It seems to me that the law that was adopted was on with respect to exploitation exploitation of prostitution was not fully implemented in all parts of Canada. So this is another challenge for the country. And these policies that are calling for changes should be really carefully assessed, because there are many forms of exploitation of women and trafficking of women related to exploitation of prostitution. So on this one, I'm cautious, and I would like to receive more information. So I would like to call for full implementation of a current legislation and full assessment of the situation. I think that this is very important policy for every government, that women should not be criminalized, and that we have to see how to reduce demand side and increase protection for women, and women should have possibility for exit strategy, especially young girls that are through different circumstances victims in this chain of trafficking and prostitution, and that when they seek exit process, they should be supported by the government.
There's a bill in front of Parliament right now. Now that it has been inserting another bigger bill on justice concerning trafficking of people, and the government delayed this bill, even if it have received first the oral assent. I don't know if you had a chance to look at that. And what is your take on this?
I think that this is important to really use international instruments there, because there is a Palermo Protocol at the UN level that is dealing with trafficking issues, especially women and children, that is providing definition and framework with respect to national laws. And it is my understanding that currently in a criminal law there is no such provision in line with accepted standards in Palermo Protocol. But on this one, I would also need more information in order to have a clear recommendation later on. At this stage, I could encourage government to proceed with adoption of that provision of the criminal law.
Thank you very much. I don't have other questions. Do you have more questions?
Thank you.
Is there anybody on the line?
No questions on the telephone line.
Okay, thank you very much.